Vice appears to be the ones who broke this story, so I will link them in the pinned comment. And the press release behind me, while old, is very relevant to what is being discussed, and we are going to touch on that in a bit. So the Preventing Private Paramilitary Activity Act is reportedly being introduced by Senator Ed Markey and Congressman Jamie Raskin. And while this passing with Republican control of the House is most likely impossible, it does put a lot of militia activity on the ballot, possibly for 2024. Because if Democrats have control of the presidency, the House, and the Senate, they could possibly put something like this through. Even more so if there are additional liberal judges on the Supreme Court making a majority, they could easily protect it as well. So what is this? This would outlaw militias, private militias, from doing things like interrupting government proceedings, acting as law enforcement, interfering with someone else's rights, publicly patrolling, and ban training to do all of those things. So all of those militias that advertise themselves as training against the government, or they appear at places like drag shows saying they're just doing patrols, all of that and more could be made illegal. Senator Markey is quoted as saying, "Private paramilitary actors, such as the Proud Boys and Oath Keepers, pose a serious threat to democracy and the rule of law." He also said, "We must create new prohibitions on their unauthorized activities that interfere with the exercise of people's constitutional rights. The forces of bigotry, hatred, and violent extremism must be stopped for the sake of our democracy." And when talking about the Second Amendment, because remember, that's going to be the big defense. What about the Second Amendment? A well-regulated militia being necessary of a free state. That's what the Second Amendment says. The problem for militia fans is that is up to interpretation. And the interpretations the courts have made so far have mostly not been in the favor of militias. States, basically all states, have laws restricting militias already. And the Supreme Court has found multiple times that the Second Amendment doesn't prevent banning private paramilitary militia groups. Arguments have been made for a long time that militia has always referred to a group the state or federal government deploys, not a private group. That is the historical meaning, and that is the meaning the Second Amendment actually was talking about. Now, of course, as you can imagine, restrictions like this would probably end up in front of the Supreme Court, but, well, there's been a lot of talk of Democrats wanting to expand the Supreme Court, but also, what happens if Clarence Thomas retires? This is from an old press release, but we need to go through it. Make no mistake, the real Constitution rejects the right-wing fantasy that random bands of disgruntled armed citizens can claim the powers of the constitutional militia to commit violent acts against public officials. The phony insurrectiony theory allows right-wing politicians to suggest that the mass destructive violence of January 6th was something other than criminal, but it was entirely criminal, and it opposed the Constitution in both letter and spirit. The fanciful claim that the Second Amendment exists to allow armed groups to overthrow the government is the basis for the equally deranged claim that the people must have an arsenal equal to the government's, but nothing in the Constitution guarantees any person a right to a military-style assault rifle, a tank, or any other military-style weaponry. So as America is hitting brand new highs for mass shootings, and of course we have people calling in threats to elected officials, and we have different groups trying to grow their paramilitary stance, I guess it comes to reason something like this would be put forward. What do you think?